Good morning, teacher and students. Today, me and my group mates were assigned to this group discussion to talk about the topic preliminary investigation. And here now we will proceed and start our presentation. Please kindly do mute your microphone and listen to our discussion. And if you're interested in asking questions, please wait patiently until we're done discussing our presentation. What is preliminary investigation? Is an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed, and the respondent is probably guilty, therefore and should be held for trial. Second one, proceeding where the public prosecutor is given broad discretion to determine whether probable cause exists for the purpose of filing a criminal information in court. This is an executive determination of probable cause. So, preliminary investigation is first held before the jury of the judge gave his or sentence. This simply states that the office of the prosecutor or district judge are responsible for this, since this will provide to assess the gathered evidences and the probable causes from the made crime to state a clear proof and explanation. Next. Purposes and objectives of preliminary investigation.
To determine whether a crime has been committed and whether there is a probable cause to believe that the accused is guilty. Determining how much evidence is necessary to justify a finding of probable cause depends on the specific facts of the situation. A police officer needs more evidence than the level required for the reasonable suspicion standard, but they do not need to have enough evidence to prove that the suspect is guilty beyond a reasonable doubt. Second one, to secure the innocent against hasty, malicious, and oppressive prosecution. This is to protect the innocent from open and public accusation of crime, from the trouble, expenses, and anxiety of a public trial, and also to protect the court from useless and expensive prosecution. Third is to protect the state from the useless and expensive trials. This is often the only means of discovering whether the offense has been committed and the persons res- responsible for it to enable the fiscal to prepare his complaint or information. It is not a trial on the merits and has no purpose but to determine whether there is probable cause to believe that an offense has been committed and that the accused is probably guilty. It doesn't place the accused in jeopardy.
Who are the officers authorized to conduct primary investigation? Provincial or city prosecutor and 3 assistants. Judge of the municipal trial court and municipal circuit trial court. National and regional state prosecutor. Other officers as may be authorized by law. In the Philippines, these are the officers who can conduct primary investigation. 1. Ombudsman investigator. 2. Official prosecuting officer. 3. Deputy prosecutor. 4. Investigating official authorized by law to conduct primary investigation. 5. Lawyer in the government service so designed by the ombudsman.
When is it required? Required to be conducted before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Preliminary investigation will only commence upon the filing of a complaint affidavit by the victim, complainant or police officer to the fiscal or prosecutor's office, and also the warrantless arrest cases required a preliminary investigation. when a person is lawfully arrested without a warrant involving an offense which requires a preliminary investigation. The complaint or information may be filed by a prosecutor without need of some such investigation provided an inquest has been conducted in accordance with existing rules.
Procedure in conducting preliminary investigation. The prosecutor will conduct the preliminary investigation to determine whether a prima facie evidence exists. In the conduct of the preliminary investigation, the prosecutor will subpoena the suspect to submit its counter affidavit or evidence to answer the allegation against him within 10 days. Prima facie, it denotes evidence which, if unexplained or contradictive, is sufficient to sustain the proposition it supports or to establish the facts as to counterbalance the presumption of innocence to warrant of a conviction. An affidavit is a written statement from an individual which is sworn to be true. It is an oath that what the individual is saying is the truth. An affidavit is used along with witness statements to prove the truthfulness of a certain statement in court.
The preliminary investigation must be conducted in the following manner. The complaint shall state the address of the respondent and shall be accompanied by the affidavits of the complainant and his witnesses, as well as other supporting documents to establish probable cause. The steps in the preliminary investigation are to understand the problem or the opportunity, define project and scope constraints, finding facts, estimate project's benefit, and estimate time and cost. Here are the steps in preliminary investigation. First one was in a preliminary investigation, the officer must first attend to any injured parties and obtain proper care for them. This step includes checking vital signs, calling an ambulance, and working with EMTs if necessary. Next is the officer observes the scene. This observation includes the position of the victim, any items near the victim, and any unusual activities at the scene. Next, the officer will make a determination that a crime was committed. Once this occurs, the officer will begin an enforcement action. An enforcement action includes pursuing an offender, making an arrest, or sending out an identifying description of the offender for the officers to utilize. Furthermore, the officer will secure the crime scene, making sure that any evidence is preserved and no one tampers with anything at the scene. Next, the officer will interview witnesses in order to obtain witness statements. And finally, the officer compiles a report of his or her work. All of this information is used in the formal post-crime scene investigation.
The prima facie evidence is such evidence of a fact as is sufficient to establish the existence of the fact unless and until rebutted, the party having the affirmative as the burden of establishing a prima facie case before the matter can be submitted to the jury. And it provides an objective, standardized approach to conducting experiments, and in doing so improves the results by using a standardized approach in their investigation. Scientists can feel confident that they will stick to the fact and limit the influence of personal preconceived notions.